but I wrote this kind of exciting teaser that I want to share with everyone before we get started. In practice group training this afternoon, we're going to journey together into the murky and mysterious world of loss of earning capacity awards in New York. For those of you who adore chaos as much as I do, you will find this a wonderful place to make a mess, turn some tents upside down, and see what comes crawling out. What is a loss of wage earning capacity award? And how in the world, if the injured worker is actually earning more money now doing the same job for the same employer, how can they be found to have a 25% loss of wage earning capacity? We'll look at the paradoxical implications of the board panel decision in JetBlue. We're going to consider the hope of mitigating factors and how to raise them successfully. We'll talk about the pitfalls of raising a labor market attachment argument, defense at classification, and how it could actually hurt you when it comes to vocational abilities. We'll apply Verone, an off-cited appellate decision that the board loves to quote, essentially for the proposition that this whole LWEC thing is a mystery, even to the board itself, wrapped in an enigma and surrounded by confusion. And finally, we'll talk about the difference between an exposure evaluation and a settlement recommendation. Come along for me as we explore new avenues of advocacy. Okay, have I jazzed you up? All right, I was hoping. Spent a lot of time on that. All right. Okay, so I've never seen anyone applaud for loss of wage earning capacity presentation before. Thank you for doing that. All right, this presentation is not advice as to any particular matter. This is an AI-free zone. Turn off AI note takers. You cannot repost this anywhere. This is for CLE credit, 1 hour. You've got to sign in, sign out. Everybody knows the drill by now. You received handout materials. I put them in the channels, various channels. And also, if you're here today, you have some handout materials in front of you. Please participate by putting away your phones or any other devices. You can't be doing work. All right, today we're going to talk about the things that impact a loss of wage earning capacity award. I'm going to talk about average weekly wage. I'm going to clear up some confusion about average weekly wage. Then I'm going to talk about what is this loss of wage earning capacity award anyway. I think it's a little murky and mysterious for some of us, including myself. The more case law I read, the more confused I actually can become. What our exposure evaluation should include and what a settlement recommendation should look like. And those are two different things, all right? The takeaways from today, how often should we be doing this exposure analysis, particularly in an LWEC case? Like, what are the case milestones when we should be doing this? When should we provide that settlement recommendation? Which again, should be different than your exposure evaluation, okay? And we're gonna talk about what the differences are. How confusing these awards can really be and how confusing the case law is. And can we turn that mystery against the other side? Can we make them prove their case? And how do we use that confusion? And the last thing I'm going to talk about is how to discount your cases and a little bit about discounting in general. Okay, so our focus today is going to be on average weekly wage rate. What is the loss of wage earning capacity exposure evaluation, discounts, and then settlement recommendations. I have a lot of slides. These are all new, most of them. I'm going to talk really, really fast because I want to get to the end and I want to look at the exemplars because I think they're interesting. Along the way, start thinking about, particularly as we start talking about exposures, how that's going to change your litigation strategy depending on the exposure as your case is evolving and as you're getting information about your case, and then how you're going to make that settlement recommendation at the end of the case. I think LWEC's an area where we should be earlier trying to figure out where this case is going. And I'll talk about some things that I even saw in the last couple of weeks in office hours where, hey, maybe we shouldn't even be fighting this LWEC. Maybe it's not even valuable for us to get an IME. So first topic is average weekly wage. I just want to demystify this a little bit. Getting that average weekly wage right is the key right from the start. It's the first part of the process. If we're not starting with the right average weekly wage, it's going to be impossible to get an accurate exposure evaluation and help you prioritize your own case. So first things first, we're going to keep things classic here. As your case is developing, every time you're touching it, go back over your classic factors. What is the claimant alleging in the C3? What's your average weekly wage? What's the litigation posture of the case? All those basics, let's keep revisiting them. Your average weekly wage can be evolving during the course of the case, and we want to make sure we're starting with the right things. Intake is doing a great job. Great job, Intake. Cases come in, there's an average weekly wage on them. But our role is to double check that information. Intake at every case. In the last 2 weeks, we sort of changed what we're doing at Intake. we're asking them to push back. If we don't have complete average weekly wage information, let's go back to the client and ask at intake for them to give us that C-240 or a wage statement or some information so that we're not just basing it on whatever the claims professional who sent us that case, their email. Because we know sometimes they're just throwing a number in there, $1,000, $1,200, $800, and they're not exactly accurate. Really important that we get that accuracy. We're going to ask the intake to look at the C3 because remember the C3 box C, claimant has to say how many days a week worker they were, what were their average annual earnings. So we can start using that as one place to get some wage information. The other place is on every FROI. There's a statement. Is this a 5-day, 4-day, 6-day-a-week worker? What's their annual average earnings? Let's take a look at those. Intake's trialing a tool right now that we're using to calculate the right multiplier and come up with the right wage. During your litigation life cycle, as you're looking at your case, remember, keep it classic, keep looking at that wage. Do we have good information, right? One of the things that Christian and I talked about is, hey, on our case status screen, I know it says average weekly wage at intake, but there's no reason you can't keep updating that as your case progresses. It'll help you over time as your case is progressing and you do determine what the correct average weekly wage is. Go back to your case status screen and fill it in. Why? It'll just give you a quick place to go find it. You don't have to go crawling back through all of your emails and correspondence. So my advice, best practice alert would be to go back and keep changing your case status screens as that number changes. And the last thing, client success team, when they audit, when they review our files, they're going to be looking for average weekly wage information. Impossible for us to give that exposure evaluation, which is right what our clients really want. They want us to predict the future for them if we don't start with the right average weekly wage. We know about the good and bad sources of average weekly wage information. Good sources, the best source is the C-240, a fully completed C-240 with the number of days worked, with their actual average actual completed annual earnings. We don't have a full year's worth of wages. Let's use a similar worker C-240. Another good place to look is your FROIs. For any version of the FROIs, they should have on the second page of the FROI the claimant's number of days worked and their annual average wages. Hopefully it's on there. Sometimes it's blank. And then the last thing I'd say is let's use an actual payroll. Bad sources of information is the C3 because the claimant is supposed to put on the C3, subsection C, every single one. Double check that, see if that's good. I know our adjusters, our claims professionals give us this information. Let's double check it. Don't trust it. Sometimes it's an approximation. Sometimes it's an average. Sometimes it's just a statement. Where does it come from? But any info from the claimant, opposing counsel, blank checks, pay stubs, anything they're going to tax returns, terrible sources, easy to forge, easy to change. Let's not rely on those. Okay, we all know that. All right. Section 14 governs what the average weekly wage multiplier should be used. 5-day-a-week worker, 260 multiple. And if you read the board panel decisions and the case law surrounding this, you'll see that anywhere from 235 to 270 days, consistently the board wants to apply a 260 multiplier, okay? The 260 multiplier is multiplied times the average daily wage that you're going to calculate, and that's where we're going to come up with their average weekly wage. So that's how the board wants us to do it. 6-day-a-week worker, more rare, but anyone with more than 270 days worked on their C-240, we should be using that 300 multiplier. Very rare. I think it's pretty rare that you're ever going to see more than 270 days worked. And then section 14, subsection 3 says, okay, you can use a 200 multiplier or another multiplier, any really fair multiplier, but it can't be less than a 200 multiple. So there's going to be instances where you've got very intermittent work. Someone works 3 days a week, 2 days a week, and we're going to use that 200 multiple. For practical purposes, use the 200 multiple anytime they have worked less than 235 days in a year. That should be our interpretation of section 14 going forward. Okay, and I know in the past I would always say, let's try to default to just earnings divided by number of weeks worked, but for consistency's sake, and so that we're not arguing things before the board that ultimately are not going to be sustained anyway, let's use a stricter application of section 14. So section 14 has 4 subsections. Subsection 4 is the one that says use a 52-week divisor of the average annual earnings. But the way you get to average annual earnings is you have to use a multiplier first. Okay, so it's one of those 3 things. The last 2 things I'm going to mention very quickly. Subsection 5 says consider wage expectancy. So when your claimants who are under the age of 25, For permanency purposes only, right, we're going to look to a similar worker who's over the age of 25 in the same employment to assess a fair average weekly wage. And again, our goal here is fairness, okay? And I also think if we all follow these interpretations, we'll have a more consistent application across the firm. The final subsection of Section 14 is Section 6, which just simply says if the claimant has multiple employments, you're going to add up their wages from all of those employments, all the employments, by the way, that they're missing time from, to calculate an average weekly wage. And again, that's just fundamentally fair. Let's just apply that. That should be our standard going forward. On Monday in our firm newsletter, I put these basic rules in that I just went over. We're going to try to apply these as consistently as we can from the beginning of the case, from intake to through the case's life cycle, and then all the way through audit, so that we're all doing this in a consistent way. All right. So first step is always getting the right average weekly wage. Then we can move into our fun topic, loss of wage earning capacity awards. Let's talk about some of these crazy numbers that are going to start emerging in your cases. Why are they going to start emerging in your cases? Because the minimum rates are going up, and they just went up dramatically last week to $384.45 is your new minimum rate for an LWEC award in the state of New York. That's pretty insane. Think about it. 3 years ago, it was $150 a week. So it's almost tripled in the last 3 years. This is going to lead to higher exposures in your LWEC cases. And that's what we're going to be talking about today, these kind of strange paradoxical outcomes that you're going to start to see in your matters going forward with dates of loss after July 1, 2026. All right, so what is LWEC? Really hard to get a great definition of it. The board says it's, quote, quantifying how much earning power an injured worker has lost in light of his or her medical impairment, functional limitations, prior work history, education skills, and aptitudes. And they like to put this weasel language, weasel words in every one of the definitions. There's no simple formula for determining loss of wage earning capacity. Why not, right? If you're going to give people giant money awards, why explain to us what they're actually based on? And the more you dive into this, the more you see a lot of the case law and the board panel decisions that are coming out keep relying on the fact that this is not as formulaic as maybe we have been thinking of it or as it's been applied. All right, so when we're looking to figure out what's the loss of wage earning capacity, we've got to go through these three major factors. The presumption, of course, is the claimant's at MMI. Listen, I know we have to litigate that in the majority of our cases because no claimant is saying, I'm fine, we're done, I don't need any more back rubs. First step, medical evidence of impairment. Second step, analyze their functional ability. Third step, what are their vocational aptitudes? Okay, these are pretty subjective things, including the medicals, in particularly a loss of wage earning capacity case. These are not hands, finger, feet, toes, eyes, ears. We're talking about feelings, and we're talking about their low back, and we're talking about pain syndromes, right? That's what we're primarily discussing when we're talking about LWEC awards. So the board is tasked to find a percentage. They're supposed to take these three relatively subjective inchoate categories or factors and come up with a percentage, which is then going to turn into money. Okay, so the first factor is medical evidence of impairment. It can come from two places, essentially. The treating physician's opinion, as found in a C-4.3, or an IME-4, right? And then we're supposed to look at functional ability. It's going to come from a couple different places. The medical records themselves, right? Because there's going to be a functional assessment in every single C-4.3 or IME-4. The claimant's testimony, because they're going to testify in this case, and any kind of investigation that we've conducted. And that could be any investigation. And the last thing is that we're supposed to consider is vocational abilities, right? And you know, if the cases, then the things that I shared with you that we're going to talk about today, the claimants all allege that they have very poor vocational abilities. So what do we do to combat that? Well, we're going to ask them for their VDF-1, of course. We're going to look at their personnel file. Let's take a look at their resume when they applied for this job, because just if you're like me, when I'm applying for a job, I'm puffing up my resume. I'm doing all sorts of amazing things. So let's look at that. And of course, their own testimony. So all those factors, all that subjectivity gets translated into a percentage. And that's where the mystery is involved in this circumstance. The judge is required to find that percentage of loss of wage earning capacity, multiply it times the claimant's wage and rate information, and then give a duration to that disability. And that's how the award is ultimately computed, calculated, and then made to the claimant. So we're talking about compensation. Now, the innovation of 2007, which we're living with today, is a capped number of weeks. If you got injured before 2007 and you injured your low back, you could get a classification that would go on forever. In 2007, they amended the statute to say, well, you can't go on forever. The maximum is 525 weeks of duration, which is roughly 10 years of benefits. What's unfortunate and strange about these durational limitations is that 0 to 15% disability is 225 weeks, and then 15 to 30% disability is 250 weeks. And as you can see, my observation is they've crammed all of the benefits down into the bottom end of the chart. So the less disabled people actually get proportionately more compensation than the more disabled people in our system. Welcome to New York, okay? Some legal references. Everything we're going to talk about in terms of loss of wage earning capacity comes from statute section 15. They amended this statute in 2017. And the statute essentially says, well, the judge is going to take a look at the claimant's wage earning ability or the wage earning capacity, determine the loss of wage earning capacity. And we get one bite at the apple at the time of classification to raise labor market attachment. So that's the only time once the person is classified that we can raise labor market attachment. So that becomes part of your loss of wage earning capacity trial or litigation. And the tough thing about this is once the claimant is found to have a loss of wage earning capacity, unless you've got some kind of wonderful due process argument that I'm unaware of, we're stuck with it. We can never raise labor market attachment in the future. Before this amendment, we used to raise labor market attachment post-classification and keep raising it. And we'd reopen cases under section 123 to do it because we challenged the person's ongoing amount of disability and use that to try to renegotiate a new section 32. Unable to do that at this time. So section 15W contains a description of the maximum weekly duration for awards. That's where that handy dandy chart comes from and says essentially it can't exceed 525 weeks. It also contains a credit for disability after the 130th week if the claimant has already reached maximum medical improvement. Okay, and I know we have some cases where we've been able to demonstrate that the claimant was at MMI at 130 weeks or thereafter, and then we were thereafter able to get a credit for that amount of disability towards our classification or towards our LWEC award. That's great. Keep that in mind when we get to discounting. All right. Section 15.6 contains maximum and minimum rates of compensation for a loss of wage earning capacity award. And here's the thing I want us to pay attention to. This got snuck into the statute. I got to admit, I didn't even notice this when the statute was amended and changed. But the statute says now that after July 1st, 2026, that was last week, the compensation cannot be less than 1/5 of the New York State average weekly wage for the year in which it was reported, except if their weekly wages are equal to or less than 1/5 of the New York State average weekly wage for the year in which it is reported, the employee receives his or her full wages. And I guess I never paid attention to that because at the time this statute was amended, the maximum or the minimum rate was $150 a week. But now the minimum rate is $384.45 a week. So it's gone up tremendously, and that's going to impact our loss of wage earning capacity award. So to translate this into plain English, an award for loss of wage earning capacity cannot exceed the maximum rate, and it can't be below their average weekly wage or the minimum rate in effect, whichever is lower. And again, I'm talking at this time about non-working claimants. A working claimant, their loss of wage earning capacity awards are pretty simple. It's going to be the difference between their current wages and their pre-accident wages. For the non-working claimant, that's the ones that we're normally dealing with. Those are the litigated cases. These are our, I never want to come back to work. I want to sit on my couch, drink beer, watch Judge Judy all day, play the lottery. This is what I do. This is my new job. And I go to the doctor once every 90 days, right? That's their new job. They're not returning to work. And they're now going to be entitled to this minimum rate or their average weekly wage, again, whichever is lower. And as I'm going to show you in the next couple of slides, that's going to encapsulate a lot of cases we probably didn't think about. So the minimum rate 2 weeks ago was $325 a week. Okay, June 30th, it was $325 a week. If claimant's average weekly wage was $295 a week, their LWEC award is for their average weekly wage times the number of weeks that their award is, right? So that's kind of a windfall. And that's only going to get bigger, and that windfall is going to be more pronounced in my observation as the years progress, because now that the minimum rate is pegged or calculated based on the state average weekly wage, it's currently $384. It's just going to keep going up and up, just like the maximum rate just keeps going up and up. Okay. So what we're going to see is some interesting problems. If you walk through these calculations, presume a January 1st, 2026 date of loss, average weekly wage, $295. Imagine the smallest loss of wage earning capacity award you can obtain, a 15% loss of wage earning capacity award, entitles you to 225 weeks of compensation. Because their rate that they would be calculated falls below the minimum rate, they're going to get $295 per week for 225 weeks. So that claimant is going to get $66,000, not $6,000. And again, this will only become more pronounced over time. In fact, I was so disturbed by this, I started trying to calculate, well, exactly where does the crossover happen? And the crossover on the minimums doesn't happen until you make over $3,251 a week for these very low LWEC cases. So in other words, your claimants who earn less than $169 and about $169,000, they're going to classify, they're going to be allowed that minimum rate, that $384.45 in your small LWECs, your less than 25% LWECs, okay? That's going to dramatically increase the value of these awards. So this week, as of last week, that new minimum rate, your new minimum LWEC exposure is $86,501.25, okay? That's pretty dramatic to me, because if you look back just 3 years ago when the minimum rate was $150, that same 1% LWEC award was worth $33,000. Okay, so it's almost tripled. And what's going to happen is it's just going to keep going higher and higher and higher, all right? It's going to mean two things, I think. First, clients who are listening, adjust your reserves for your new cases, particularly with your dates of loss after January 1, or July 1, 2026, right? Because this is going to be your new floor, okay? And then for us, litigators, we got to litigate some of these really low value LWEC cases, because they get any numbers on the board, they're going to be able to get a pretty sizable award, okay? So this is something that's changed recently. And again, it's just our happenstance that we're doing LWEC this month, and it just changed, and it's pretty interesting. Again, I think the system is messed up. I always trot out this slide. We've crammed a lot of the benefit down into the bottom end, or the least disabled people. And as you can see, it's a pretty flat compensation scheme that we have in New York. Vote for me for governor of the state of New York, okay? I will change this. I will make this a more linear progression instead of flat, but it's not fair. All right, so how does the judge come up with this impairment? What are the factors that we're going to argue? Well, medical is the first factor, and it's the one that's easiest to sort of quantify, easiest to wrap our heads around. And I just want to show you a couple things about that, okay? So the first step in coming up with this percentage, which again is going to yield a compensation award, is we got to look at the medical evidence of impairment. Where's it coming from? The treating doctors and the IME doctor. And, hopefully there's a good reason we're getting an IME. I'm going to demonstrate to you some reasons why we might not want to get an IME, and we might want to go with the treating physician in some of these cases. So the guidelines that determine how the doctors are supposed to determine impairment came out in 2012. They are unchanged. And even though psychiatric conditions, low back, cervicals, neurologic conditions are all amenable to a loss of wage earning capacity award, I don't want to skip over the fact that your very significant schedule loss sites, arm, shoulder, knee, hip, that go over a 50% scheduled loss of use, those are also potential LWEC award sites as well. So be on the lookout for that. Determining the degree of medical impairment, well, the physicians are instructed that MMI still has to be found. It's impossible for them to give a classification and a severity ranking to a disability and say the claimant is temporarily totally disabled, right? They've now reached MMI, and now they should be classified with a permanent residual disability. We've seen these things. I know you guys are familiar with chapters 11 through 16 of the 2012 guidelines. Like, you know them like the back of your hands. Okay, all right, good. The doctors don't. These guidelines look at 11.1, 11.2, 11.3. That's where 85 to 90% of your cases are going to be determined. based on these impairment tables. These impairment tables are very upside down. They are designed in such a way that if the claimant literally shows up and says, ouch, my back hurts, that's enough with any evidence of treatment and any evidence, radiographic evidence, for them to get an LWEC permanency award. If you look at how these tables are designed, and this is a non-surgically treated low back, cervical spine, thoracic spine case. If you look at how they're designed, if the claimant comes in and says, I got injured at work, but I have no symptoms, and there's no clinical findings. And remember, a clinical finding can be pain or just says their back aches, no disability. Okay, that makes sense. But if they come into the doctor and they say, like, I had a medically documented injury and I have some symptoms, but there's no objective clinical findings and no correlative imaging findings, meaning clean MRI, clean EMG, no findings at all, you're still going to get a permanency ranking from the doctor. They have to give you one, right? And this is why our IME doctors are giving you 11.1 A's and B's and 11.2's A's and B's. It's literally the lowest they can go if the person says it hurts and they say they had an injury at work. They just can't go below that, all right? And this should inform us of something. On office hours this week, I was looking at a C-4.3 from the claimant's treating surgeon. It was actually the surgeon who performed the surgery on them and gave them an 11.2B. And I'm like, that's as low as it goes, man. Don't get an IME. You can't do better than an 11.2B in an operated back case. It's not possible. That's the best number our doctor could have ever possibly put on it. Don't get an IME. It can only hurt you. Why? Because the IME doctor could find the higher number, right? And that could expose us further. So be thoughtful about how low these numbers go, and there might be no grounds to get an IME. So, as you're thinking about assessing your case and looking at exposures, another example, both doctors have we have an 11.1A and they have an 11.1B. Why would you take the other doctor's deposition? What could you possibly do with that? They agree essentially. And actually they agree in academic terms, because when you go to the crosswalk, you'll discover those things actually equal the exact same amount of disability on the crosswalk. So no point in deposing those physicians. The second part of these findings is this severity ranking, and it's simple on chart 11.2. But some of the charts you have to go to other charts, supplemental tables, in order to figure out the severity rankings, and particularly radiculopathy cases, right? Where the person says they have shooting pain going down their legs or down to their fingertips. The doctor has to go to these supplemental tables. Now, this is going to be important when we look at the two exemplars that I handed out today. You're going to realize something very interesting when you look at the claimant's surgeons or the claimant's doctors, C-4.3, right? It is impossible for a classification to have a table 11.4 finding it, or 11.6. Not possible, okay? So a little bit of a hint of things to come. All right, next step. We've got severity rankings and impairment findings from the physicians. My advice is go over to your handy dandy crosswalk and try to turn that into a number. As you can see, of lumbar injury, A, B, or D is going to AB, because there can be no C, by the way, of severity class 1 can only give you a 16.6% disability. That's why I said when their doctor gives them an 11.1B and yours is an 11.1A, why would you take depositions? It's academic. They have the exact same findings in terms of impairment percentage, right? So that first part of your LOIC formula is going to be the same. Don't take those depositions. It's a waste of time. As you go through this crosswalk, you can compare the findings by the physicians and determine, hey, where are they falling out in terms of percentages, right? So utilize the crosswalk. It's on page 120 of the 2012 guidelines. All right. Again, think. This is the moment to think. Do I need to take this deposition? Do I need to should I even get an IME? Do I need contradictory medical? And I'll tell you, your 11.1s, 11.2s, A's and B's, don't bother. And don't think there's any real good reason to do it. All right. Again, because it's academic. All right. Now here we get into our paradoxical moment. So now we have a finding of medical impairment. The board goes out of its way in decision after decision to say, well, impairment doesn't equal disability. These are not congruent concepts. These concepts have nothing to do with each other. In other words, you could have very little impairment and a lot of disability in the board's mind, and a lot of disability with no impairment whatsoever, right? They keep saying, and they keep citing this case called Matter of Petchog, and they keep citing Verone over and over and over again. If you go back through the last year of board panel decisions, they keep saying this, quote, while the impairment rating may coincidentally be the same percentage as the ultimate finding of loss of wage earning capacity, the medical impairment rating is not to be used as a direct translation to loss of wage earning capacity. Okay. Keep that thought in your mind, right? Because just because we get an impairment rating from our physician or their physician, the game's not over. You can keep arguing this just like the board argues it when they want to find more disability. In other words, give someone a huge 60% LWEC for very minimal medical impairment findings. Well, you can make the opposite argument, right? You could say, well, then just because my doctor gives an 11.3 J, as bad as it could possibly get, so what? So what? And I will point to the case Verone. In Verone, we have a 47-year-old construction site manager, significant injuries to his neck, his right shoulder, both wrists. In fact, his wrists at the time of classification, he was in wrist braces. The defense IME found an 11.1 F, which again is about as high as you can possibly get from a defense IME. Crosswalk that, that's a 50% impairment. But the board only gave him a 15% loss of wage earning capacity, essentially saying, yeah, sure, you have a bad back now and your shoulder's messed up and you're wearing these wrist splints, but you can do the same job you were doing. You were a site manager, you were a supervisor, and you were checking things off and you were directing people. So they gave him a very low finding. And that case got appealed, went up to the third department. Third department came back and said, sorry, it's a credibility determination. We're going to leave that in the hands of the board, right? So it's not just because you have a high impairment rating from your own doctor, that doesn't mean you're going to get stuck with a high LWEC. You got to look at the other factors too, right? And they should, I think particularly, they always say in law school, you have the great facts, argue the fact, and your great law, argue the law. You got neither, you just obfuscate. So if you get a case where you've got a real bad IME opinion that gives you basically as high as you can get from an IME doctor, say, okay, impairment's not going to be my best chance here. Let's take a look at the next two factors, right? And remember, those next two factors are functional evaluation and vocational assessments. Okay, so functional and vocational assessments. So functional evaluation, it's included in all the doctor's reports. They're pretty much check the box exercises to me. I know they're not doing functional capacity evaluations. I rarely see it being done. I'm a big advocate for those. I don't see them. But take a look at what were they doing at the pre-accident job? Did it require somebody to do more than sedentary labor? Even our 11.1 A's and B impairment findings, I'll still see from the doctors. In fact, the one I gave you today still says he can only do sedentary work. Okay, so what? Is he like Verone, who has great transferable skills and can still do that at injury job, even though they're not working? You can make that argument, right? That argument's not off the table. We know what the doctors are supposed to do in terms of these functional evaluations. I don't believe they do them at all. I think they just have the claimant fill out sheets or forms or questionnaires. I don't think they look at it. The next thing is the court's supposed to look at education, training, skills, age, literacy, and more frequently, they keep putting in board panel decisions, computer and smartphone skills. That's why I included the case today, JR Interiors, where the claimant says, well, I don't speak English and I can't do this and that. And the judge is like, well, I just saw you using your smartphone. So you obviously have some computer literacy and some computer skills, right? So that's something that we can at least try to bring out. In Southeast Towers, same thing. Claimant was shown using his smartphone. The judge says, all right, you have some transferable skills. That's a skill in and of itself. So don't give up on these vocational factors. Look into them. Now, be thoughtful about them. Read the JR Interiors case. When you read that case, you realize, well, they got to the time of classification. They made their arguments about impairment. They made their arguments about functional ability. They made their arguments about vocational ability. And then they cross-examined and beat the crap out of the claimant, it looks to me, on their labor market attachment argument. So maybe think to yourself, if I think I have a good argument that they have all these vocational abilities, maybe I want to be attenuated or thoughtful about my labor market attachment argument, because I don't want to undermine that position on vocation, right? Because we're trying to show to this judge, yeah, they might have a high medical impairment, but their vocational ability is actually much better. So be thoughtful about that. All right. The judge is supposed to take all three of these things, set a duration, calculate the LWEC. It's relatively straightforward calculating LWECs. It's going to be 2/3 of their average weekly wage times the LWEC percentage is going to be their benefit rate. And then we're going to go onto our lovely weeks chart and determine the duration of that award. Pretty straightforward. I don't think anyone has trouble with doing this basic math. The only time I want you to be very thoughtful and careful is when you're dealing with your low average weekly wage earners, or you're looking at your earner who makes less than $169,000 a year, which I got to tell you is going to be like 80 or 90% of our claimants. And the award is going to be for a very small amount, 1 to 15% LWEC, because you're going to get into that minimum rate issue that can still come back and put a lot of value into your case, or a lot of exposure value, I should say. All right. Last thing I want to talk about today is exposure evaluations and settlement recommendations in our LWEC cases. And I want us to be thoughtful about this. These are two different things, okay? In my mind, they're two separate ideas. Exposure evaluation is as the case is progressing, I'm telling the client, here's what's happening. We just got this milestone event. I got an IME4. Based on this IME4, here's what I think our exposure is. You can do that as the case is developing over and over again. A settlement recommendation is different. It's at a point in time. I'm now telling the client, this is an opportunity. Here's what I think the case is worth today. Here's how I discount it. Here's what we should make an offer. It's very specific. It's anchored in time. And I'm asking the client, we have an opportunity here. Let's do something with this, right? So exposure evaluations, I think we should be doing constantly in our cases. I know we're doing them mentally in our cases, right? When we talk about them in office hours or caps, we're kind of getting a sense of what the case is worth. We should be transmitting that to our client, even though we're not yet recommending exposure, okay? Evaluating exposure in these cases, again, we're gonna go through this 3-step process. We're gonna come up with this percentage LWEC that we're gonna think is the right number. You know, both sides are gonna get these reports. Take a close look at your reports, all right? Let's look at my exemplars that I pulled out for you. Live case, real case. Just look at the LWEC portions of these IME reports and C43s, okay? Just look at the classifications. I know this case also involves like a knee and a shoulder or something else. Ignore the SLUs, okay? Just look at the LWECs, okay? Our doctor in this case, in the IME4, found disability to the lumbar spine from impairment table 11.1, severity ranking 3B, okay? All right, about as low as you can get. Good, I'm happy with that. Treating physician, in this case, gave an opinion, table 11.4 and 11.6, severity 4E. Okay, that's interesting. So if you look at our IME4, you can go figure out, was the doctor right? Because we're gonna compare whatever the doctor says to the actual medicals. So you can look into your case and you go, okay, well, I'm gonna compare the treatment and the symptoms to the finding. In the finding, you go to that table 11.1, he says class 3, and then you go over and say, okay, class 3 means recurrent symptoms, has some spinal pathology that shows up on an MRI or radiograph, right? So they got a bulging disc somewhere, good for them. A doctor found an 11.1B lumbar. Again, about as low as you can get, good for us. If you look at the crosswalk value of that, it's the next step I would do. Go to the crosswalk, figure out what's it worth. Well, it's pretty simple. On the crosswalk, you can look at that 11.1, right? We're in tables, all 3 tables, 11.1, 2, and 3, which is where all the impairment ratings are going to come from. Look at the severity. He gave you a severity, or she gave you a severity B, 16.6% medical impairment. That's where you're living right now. That's where you're starting from in this case. Okay. Now, skip the rest. You don't need to look at them. Now, let's go over to our adversary's doctor. Adversary's doctor on their report says 11.4 and 11.6, severity ranking 4E. Please read the disability duration guidelines, the 2012 guidelines. Those don't exist. This doctor got confused. Okay, this IME, this C43 is invalid because Those two tables are supplemental tables, right? Supplemental table 11.4. These are supplemental tables that the doctor is supposed to be using to determine severity rankings, and then go back to the correct tables, 11.1 or 11.2. In this case, it should have been 11.1 because there's no operation, and then apply that severity rank. Okay. But they didn't. They created their own tables that don't exist. They're not right. I get what the doctor was trying to do here, but it's not possible. All right. These are supplemental tables used for assessing severity, not for determining impairment. Okay, so what do you do next? What would I do? Well, I would now feel pretty good about cross-examining that adversary's doctor, right? Because at best, I'm going to be stuck with my doctor's opinion, which is about as low as you can get. A 16.67 is as low as you can go in this system, right? If someone has complaints and shows up, they're going to get an 11.1A or B. Their doctor has an impossible finding. I think you could kill them on cross, right? And get them to be found completely incredible, or they didn't know how to apply the guidelines, and they would probably try to fix it and testify correctly on the stand. But I think you have a pretty good argument in your summation that, Judge, you shouldn't put any weight on this doctor's opinion. They don't even know how to use the guidelines. They shouldn't be using the guidelines. In fact, they shouldn't even be coded. Judge, let's get their license to practice medicine yanked, right? Go for it, okay? So next step, all right? Now you've thought to yourself, okay, and the point I guess I'm bringing up with this is that, you know, your exposure analysis, as you're doing it as your case is progressing, it could suggest to you your litigation path, right? In some instances, you'll say, hey, I shouldn't litigate this case. And there's no value to litigating it. The doctors are essentially agreeing, or it's academic. Or in this instance, you'd say to yourself, well, I definitely want to litigate this. I definitely want to cross-examine their doctor because my doctor is going to be found more credible. They actually applied the guidelines correctly. Theirs didn't, right? So that's the value of doing this exposure now as the case is progressing over and over again, and not just waiting to the end of the case, or not just waiting until your client says, hey, what's this case worth, right? It help you plan that out. All right, next we calculate our exposure evaluation. Look, a 16.6% impairment. We got to consider the functional ability factors. If you look at those documents, both doctors agree the claimant has a sedentary work ability at this point. Consider vocational factors. Again, this is a hypothetical case. I don't have them. I don't know how strong they could be. My evaluation of this case on an LWEC basis would be 20 to 25%, right? Again, it's relatively academic. Why? Because between 15 and 30%, it's the same duration. Doesn't really matter, right? But again, I'm imagining the judge will find it between 20 and 25%. By the way, if you look at a lot of the board panel decisions, they're all either 25% or like 60%. You don't see a lot in the middle, right? So maybe that will help you in your evaluations, particularly after you just look at the impairments. Assume a date of loss today, $1,000 average weekly wage, 250 weeks to be paid at the minimum rate in this case, which is $384.45 or $96,112.50. That's before you start applying your discounts, right? So again, we're just talking exposure. We're not talking about settlement. To talk about settlement, tell the client, here's what my recommendation is. Here's what I think we should do next. I've got to discount that. Okay. And this is where we put on our thinking caps, right? What's the litigation risk that we have? What would be the benefit of going to trial? In this case, you might have a good benefit of going to trial because you think their doctor's opinion is based on a misapplication of the guidelines. So you might have a pretty good, strong reason to go and litigate that case. Cases where the demand from opposing counsel is exceeding 75% LWEC, it's going to get you into that extreme hardship redetermination problem in the future. What's the downside to trying those cases? Probably not so much, particularly where the medicals are bad. Please, most cases that are going to go for total, unless this person is like a double amputee and it's a statutory total, you should be trying those cases where their doctors, where they're arguing that stacking up all of these body parts, right? You have multiple classifications in the same case and they're arguing for total. There is absolutely not one shred of case law that directs judges to stack classifications, to stack LWECs. Nothing says that. In fact, case law says the opposite. It says you are not to stack them. The judge has to consider the person as an entire working unit, not just a collection of disabilities. Okay, so, you know, I would make that argument as well. Consider the value of right now money to the claimant. Why? Because I'm always thinking about how do I section 32 these cases. We'll use the ATF tables to discount to present value. consider indemnity only. So you want to be thinking about your options and ways to discount this case. Other ways to discount it, of course, would be things like, do I have a risk transfer opportunity, right? Do I have a good fraud or COVID argument that I could bring into this case? Do I have a 130 weeks Section 15W argument, right? That I should be getting a credit because they actually reached MMI years ago, okay? Consider the strength of your labor market defense at classification, okay? Because you're gonna go forward with your impairments and your functional abilities and your vocations, but the judge still has to determine that they're attached. How good do you think their attachment proofs are? Did they really look for a role within their restrictions? All of those things. What proofs do they have? Again, this is how you're going to discount that settlement. And then again, always considering that value of right now money. We're going to then present discount the case. Whatever you think it's actually worth, we're going to present discount it. The board bulletin gives us a 5% discount rate. Simple back of the envelope math. In this case, present value discounting would take it from 250 weeks to 222.13 weeks. It basically knocks the dollar value of that LWEC from 96,000 to about 85,000. Okay, so that's sort of your floor, I would say, in this one. Assuming neutral litigation risk factors, no potential for risk transfer, and the claimant can show attachment proofs and a positive effort. My Section 32 recommendation today, $80,000. Yours could be $90,000. Yours could be $100,000. I would bet that with 40 attorneys in this room and 40 paraprofessionals, if we, courted this case, we would all come out to a Section 32 value probably between $75,000 and $100,000, depending. Is it close to Christmas time? Do we know anything interesting about the claimant, like they're about to move or they want to buy a new car? Anything that we could pick up from the medicals that would be useful in helping us discount it. But that's what I would tell the client. I would say, client, give me $80,000 Section 32. Let me go talk to opposing counsel and see if I can get this thing tied up. And again, the threat to opposing counsel is they still have to show labor market attachment at the time of classification. I'm sure their demand would be much higher, right? Everybody knows I'm very careful with my clients' money, but reasonable minds could disagree about what the actual 32 value of this case is. But what's important is when we transmit this recommendation to the client, it's a specific recommendation, okay? And in this instance, I think you could do one of two things. You could say, look, we think their IME report is weak. We think ours is pretty strong. However, even if the judge adopts ours and says our doctor's more credible, implied the guidelines more correctly, you're still looking at a 16.6. We know this judge, we know the venue, you're going to get between a 20 and a 25% LWEC. Here's the value of the case. If you prefer, I'd like to go try to attempt to do a Section 32, and I would try to do that 32 for put your specific number in, okay? Remember, our lingo here is we make settlement recommendations, okay? We make settlement offers to opposing counsel. When opposing counsel makes a demand to you, please never call that their offer to settle this case, okay? That is their demand to settle this case. Now, this is an annoying nuance that I harp on all the time. It actually makes a very big difference to clients when we use these words correctly. So we make offers, we make counter offers, they make demands, they make counter demands. Let's keep that straight, particularly when we're talking to our clients. All right, what not to do, you've seen this slide before. Do not be a plain old calculator. Our clients all have wonderful tools in front of them. I'm sure they know how to calculate an LWEC. They don't need to see your math. I think you could tell them, hey, we think it's 20 to 25% LWEC. It's going to be $96,000. It's 250 weeks. Here's the value. That's enough. You don't have to go into the weeds as to how you came in there. Please don't give them ranges. Even a narrow range should be avoided if you can. Our clients are looking for the benefit of our experience, right? Which is predicting the future, which is trying to get to a very specific number. I always like to remind us that some of our clients do not want to settle cases, particularly where they have some money, time, blood, or treasure invested in that case, and they might not want to settle. And I say, try it. Let them win, make them put their proofs on the stand. All right, some takeaways from today's presentation. I guess the first one is that I didn't put in the takeaways is be wary. After July 1st, 2026, you're going to start to see your minimum exposure values in these LWEC cases go up, particularly for your claimants with low average weekly wages. So just be mindful about that. Every step in this process, as exposures are being evaluated, That's a chance for us to kind of reconsider our litigation position. I think if I just saw the claimant C43, I never saw our IME4 in this case, I would have been saying, man, they have a problem in their case right now. They have a real proof problem that they're going to have to solve and fix. Can they fix it by getting another report? Sure. But does that impact the claimant's doctor's credibility? I think it does. I think that would help me. As your case is progressing, it's okay to keep reevaluating exposure. Evaluate it soon, evaluate it often. You can't do it too much, really. And it's okay that it's changing as the case is progressing. If the evaluation is not changing as the case is progressing, do the clients need us? Are we actually providing any value? No, right? That's our job. If you're timely looking at these exposure evaluations or doing them as the case is progressing, it's going to help you make better litigation decisions. Again, we don't have to wait for our IME to come in to start evaluating exposure in an LWEC case. And start thinking to yourself too, I mean, particularly in a case where, let's say the adversary's doctor comes in with a good number, right? I saw in office hours yesterday, 11.2A from claimant's treating surgeon. I was like, stop here. Let's not get an IME, right? Focus on your other factors, focus on function, focus on vocation, focus on labor market attachment. That's where all of the effort in the case should be. Medical proofs that you're not going to do any better than you've already done. So part of being a great litigator is knowing when to stop litigating, even though that's what people pay us to do. Sometimes stopping it and changing the direction that you're going in is important. Know who your stakeholders are. Okay, I always say, like, let's make sure our adjuster or claims professional is up to date in our file, so we're communicating our settlement recommendations to the right person. All right, other ways to learn. We have an email newsletter. Christian's podcast is coming out next week. Enjoy that. And finally, after this presentation, rate your presenter. Thank you, everybody. Have a great day.